Good. Nerd.
Puff puff pass. True crime chat rats. Let's go. Puff puff pass. True crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rat pack. With my rats chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats. True crime social where we be every night, doing everything we do for the truth. With my rats chatting about the crimes, the players and the evidence. Like it all went bad. Taking all the facts, and we bring them to the chat rats. All my people on the internet, all my people from around the world, gonna take you to the place we know best. Cause we're coming through like that. Puff puff pass, true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rat pack. With my rats chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats. Puff puff pass, true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that.
What's up? What's up? What up, Dean?
Yo, what up, bro?
That's Dean's call sign. Yo. And Sweet
Yo.
Woman tried to use it. Sweet Woman tried to use it. Look. It's not here anymore. But she
Tried to take my thing.
Yep. Tried to take it.
That's fucked up. I see. I see. MJ
Yeah.
says peer pressure always wins. But something trumps peer pressure,
Uh-oh. What does?
and that's queer pressure.
Oh, that's a lot of pressure.
It's a lot of man-on-man pressure right there.
It's pressurizing.
How's your day, bro?
Oh, man. Just rainy here. I looked at the weather and I was like, fuck yeah, I can go cut the grass. So I went outside to cut the grass and it rained the entire time. I just kept cutting it.
That's shitty. It didn't. It's really sunny here.
Yeah, it's just started raining again here. Thunderstorming.
Yeah, it was like that the past. Not yesterday, but the day before. Probably where it came from was over here.
That's pretty accurate on our characters, huh?
Yeah, I think so.
Pretty accurate.
I think so. I got I'm getting bullied by my friends for using this icon. They're calling me a furry.
You're a furry.
Yeah.
Well,
Apparently.
you can't be a furry just in the internet. You have to have something at your house that's furry.
Is that true?
I don't know. I was trying to help you, give you something to go back at them with. You know,
Yeah. I don't think they're gonna listen.
furry things get petted more.
That's true.
It is. Oh,
It is
Gingy's
true.
here. What's up, Gingy? Better be
Yeah.
here since y'all forced me to do this. Forced my hand.
With that queer pressure.
Yeah. Petty, how's the foot feeling? Cannot feel good, but maybe it feels better.
Yeah, what'd she say? I think like 6 weeks.
Yeah, it's pretty bad.
That's rough.
Pretty bad. Kids
Yeah.
make fun of me.
So
Oh, God. Oh, what pics?
the pictures of the rats.
Oh, okay. Yeah. Toys have got a new video coming. It'll have all the rat pictures in it.
Nice.
Got to change some of the words in the songs now too.
Really?
Yeah, because TCS is all up in there,
Oh,
and it's gone. She gone.
that
It's
bitch
gone.
gone.
That bitch is gone. Grabbed up, packed all her shit and videos, and left.
It's like a Brooks and Dunn song.
Yeah, took all the hours with her. Crazy bitch.
Yeah.
That's a song too.
That is a song, yeah.
Hey, there's only 3 people here. I mean, what could we do wrong?
That is true.
It is true. Seems
What
like
could
there
we
was
what could
more
we
than
do right?
more than 3 people trying to convince me to do this, if I remember correctly.
Apparently it's actually 4. Get your shit right, dude.
No.
Come over here with fucking facts, bro.
Yeah, receipts. Get your receipts out.
Facts.
Yeah. Oh well, we're gonna watch this fucking closing arguments. See how it goes.
Sounds good. Sorry.
I see JFK's live. I try to wait a little while so everybody gets tired of listening to the song or whatever. Sorry, I'm messing with all this shit. I should have done it before I got it going, but whatever. I'll do it now.
I'll never forgive you.
Yeah.
Neither will anybody in the chat. Don't forget to hit the like button, guys.
Yeah. It
Share the
helps with the algorithms. Yeah, I'm ready if you're ready. You ready?
No.
Good.
So I have started fascinating mornings by saying you folks, I apologize for the inconvenience having you wait around so long. I appreciate your patience. I didn't want to do that today, but I had to do that today. Everybody has worked so hard on this trial, the jurors, the lawyers, the witnesses, that everything has to be right before you hear it. So I needed to do that this morning. I apologize. I do have to ask you those any questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since you were here yesterday? Everyone said yes or not affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or not affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So as you know, it's time for closing arguments. And when I was a trial lawyer, I never liked it when just before closing arguments, just before I stood up, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. Closing arguments are not evidence. The lawyer's not witnesses. And because they're not evidence, they need to put away in notebooks because you can't keep notes. But the reason it used to bother me was because I sensed that it made it sound like they're less important than anything else in the top, and they're not. They're certainly a very important part of the case. And we've all noticed that you paid very close attention to this case, and we know that you'll do the same to the closing argument. A couple of things I want to say, and you'll hear more about this in greater detail when I give you the chat. First is, you folks are the fact finders. So it's what you find from the testimony, your memory of the testimony. This has been a long trial, but your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, the constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden of proof. Right? The burden of proof is on the Commonwealth to prove beyond a reasonable doubt to a moral certainty. And because of that, in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing arguments. I've given each lawyer an hour and 15 minutes, and I'm not going to stop them. So we'll start with the defendant's closing arguments. Jackson.
Was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. Because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Kenton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, was a Canton board selectman. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Martin McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor and his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well, he got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look. Sparring. practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about.
Looks like his mind's where Dean's mind usually is.
Where's my mind?
Standing behind another dude, grabbing him in a bear hug.
It's not a bear hug.
It's a hug, though, from behind.
It's a thrust.
It is.
Yeah.
I hope there was no thrusting. Thrusting is not good.
No, it's not.
Unless you
I mean,
got
I guess it depends on who you are. Is
who you
it
got
good?
bear
Is it
hug.
bad?
It's who you got in the bear hug that matters, I think.
Do you want to be in the front? Do you want to be in the back? You know, it's all
Neither.
perception, you know.
It has definitely got a different perception.
Yeah, well, I think perspective, actually, you were right.
Both.
Yeah.
Let's just say it's both. Connor Macananis. Went back to Macananis and cheese, huh? Sweet. Our names never die. Just ask Lauline. You get that. You get a nickname, you're stuck with it.
What's your nickname?
I don't have one. Oh God. I hope you didn't injure your ankle again. Oh God. You're retarded. You're retarded.
Totted.
What you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor in his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him, tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John. A gesture that looks a lot like, let's step outside. Let's go outside. And John looks at him, takes a swig of beer, completely ignores him. Take a look. Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw.
I have to say, I don't like it when the screen goes black like that. It's not fun.
Why did a few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You coming here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to John's, her phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. And as you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn, just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learn through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scordavello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert, think about this, not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scordavello's words. Question. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scordavello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own expert said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scordavello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV, period, full stop. Dr. Dan Wolf did the testing on the taillight, actual testing, not some ridiculous blue paint kindergarten project. He did lab testing, he did field testing, he did data testing, actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rinchler, PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory. Why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came through in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it to get the results that he wanted. Dr. Welcher then claimed the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitated. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading text on his phone, and locking his phone, all of it, after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question, can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claimed he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffin's data, Ian Whiffin. John O'Keefe took 31 steps at a steady rate, about 83 feet. And then think about this. In a westerly direction, that would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffin himself conceded that he has reasonable doubts about the accuracy of John's location data. You remember that question and answer on cross-examination by Mr. Leslie? Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation. This is science, and it's irrefutable. It tells us that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Whiffin told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welsher, Andrew Winchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What can make you fall straight back like that? Let's just think about that for a second. What can make you fall from a standing position, as Judd Welcher just showed us, standing up, falling straight back? Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPosada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear.
It's hard to stop this and talk because I get so lost in it.
Yeah.
Listening. I'm listening, Dean.
So what do you think so far, Danny?
Well, I think because I watched them both yesterday or whenever, that Hank did a really good job with what he had. And I was surprised. I didn't expect him to be able to do that well, but she just kind of let him say whatever the fuck they wanted to. I thought she was going to get pissed at some of the stuff that Alan Jackson said, but she just let him roll with it. Which I guess because they've already had enough misconduct for several mistrials, so they might as well let him have it.
Yeah.
The shit with the T-shirt should have been fucking some kind of sanction on Hank or something. You know what I'm talking about by that?
Yeah, well, I'm familiar with sanctions.
Well, the T-shirt, the DNA person had cut some people out of the back.
And
he's like, "What about these fucking?" I was like, "Okay, are you the only one that don't know?" And the judge is sitting right there and just let him keep on. She didn't stop him.
Yeah,
it's like, what the fuck is going on?
Sanctions it's really hard to get sanctions on an attorney. Like really hard.
Well, at least from Bev, like something.
Well, especially from Bev, but just in general, sanctions you can file for sanctions, but
Yeah.
they almost never go through. At least according to my lawyer when we were gonna file for sanctions.
Did you just talk to your lawyer like right now while I asked you that question?
No, I'm saying I was in a situation where the opposing counsel didn't share evidence with us, and my lawyer was like, it's really egregious and I want to file for sanctions, but the likelihood of it happening
Yeah.
is so low. And he told me how they rarely get ruled for.
Are you done talking about yourself?
No.
There was no collision.
All
Dr.
day.
Wamasada told you in probably the worst voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan. Did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rinchler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Sportybello, not Dr. Azekliff. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case would be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher: it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, when you think about this, in a kitchen, in a house, 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course, this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering. But here are the highlights. Proctor starts the conversation. Quote, all the powers that be, one answers ASAP. He's getting pressure, obviously, to get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whacked up cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass bitch. She's got a leaky balloon knot, leaks poo, 0 chance she skates. She's fucked. And up to this point, Michael Proctor had done 0 investigation, nothing, save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Butnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder. No bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life? The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who was charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from him. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated because the Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias. Bias in this case. Fired. This is the man who touched every.
That's a hell of a point to be able to make right there. You don't get to say that often in a trial. That the investigator that did all this investigating got fired for his investigating.
Yeah, that is a pretty good point.
Pretty strong point.
Pretty strong.
Strong with an S. We're strong with an S.
Very stronger.
You get that old, the old lady who smoked too much.
Yeah, those Virginia Slims.
Yeah, she's in Louisiana somewhere.
You're gonna be a star, kid.
You keep going, kid. You don't care what they tell you. They may say you sucks, but you do. But you still go.
You'll make it big one day, kid.
Yeah. Maybe not in this life, but you will make it.
Every single piece of important evidence in this case, all the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts.
Shards really would go through your hand, Dean.
Yeah. Sure.
Way to back me up.
The shards. All in Michael Proctor's possession.
Thanks for backing me up.
No.
Okay.
Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. But he failed to ask every single witness, is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for.
And whoever just subscribed, sorry about the long wait, the 20-minute wait to chat. But we got some fucking rules around this place, Dean.
Yeah. We got fucking rules. Yeah.
Yeah, rules. I don't know. I can't name any of the rules right now. But we got them.
They're there.
Pretty much
Better
on the internet.
not fucking break them.
Fucking better not.
Before they were submitted to the crime lab, before they were ever scraped. Still look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to put those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They got nothing. Not a single piece that the Commonwealth wants you to believe cut up.
That's on Dean's page where they have the gay ass rules.
Those aren't gay ass rules. Those
No,
are
they're
gay ass
gay-ass.
play.
Okay. Well, there.
Yeah.
I mean, there's no rules to that either.
There's no rules. The only rule is the strongest man wins. You know what I mean? That's
Up John's arm. How is that possible? It's not possible. The
Dog
only
eat
way it's possible
dog in
is if
there.
those shards never touched his arm. Because he was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing. Not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with the car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just hung there, just hung on. That same hair that moved in between photos in the Sally Port. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves is that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing, the Proctor glass. Those two go together. The only two things that go together on that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash, didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long?
Definitely gonna
Years
choke.
even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night. Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said the very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? Wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth has presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk, she wasn't stumbling, she wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, using location data on John's phone showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for alleged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door at the garage. I was asking her about the front door, the side door, and the garage door, and her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Read. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with him for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins, and Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history, a dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they have something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabes. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was timestamped by Celebrite at 2:27 a.m. A Google search that read, "Huss Long to die in cold." It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia? Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom. It tells you everything you need to know about the character and quality of the prosecution's case and their witnesses, lying and perjury and admitting to it. A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was in real time. She was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all this stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling them everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, I hit him. Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video, it's not on audio, it's not in a single police report, it's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, I hit him. You saw the video, multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered, he's bleeding, his eyelid is cut, his nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, shut up! Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house, Brian Albert's window. Jennifer calls her sister at 6:07 with all this chaos going on. No answer. Jennifer calls her sister at 6:08 with all this chaos and bedlam going on. Still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts established a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that in the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you had any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moments that Higgins would be at that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch. That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight.
Stacey.
What does that say about the character and quality of this case?
What's up, Stacey? What's going on? Yeah, I'm trying to find the Discord link so I can post it out there. Dean, you alive? Didn't think so. Hopefully he's just asleep, like normal. But yeah, I'll get it in a minute. I'll find it in a minute.
It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the
Sassy, tell him that's how I got to here. I'm sitting around watching my wife watch these different trials, and then this one happened, and I was like, oh, I kind of like that. And now, here we are.
defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop, and all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became What did she say? A false memory. Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate. Is that a righteous test? Or was that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining him about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. If that test does not represent the theory of the Commonwealth's case, really, then why was Dr. Welcher playing dress-up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding...
Prince Lover, that Discord link is in the chat. I posted it up there, but if you're not on Discord yet, you need to download the Discord app. A lot of crap goes down in there, and that's where we figure out where everybody's at, who's watching what, and who's doing what. I already posted the link, Dean.
You posted the wrong link, dude. The one you posted only
trying...
works if you're in the Discord.
Okay. See, well, that's why Dean's a mod, because he told me how to do this. Now he's going to bear the fucking responsibility of link dropper. Dean's dropping links.
Yeah.
Or I could just make him a standard moderator.
Damn, you're gonna demote me already? Nah, I don't care, dude.
That's all right. I'm just messing with you.
Holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight? If he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory. The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics, has become very pesky to the Commonwealth because there was no collision.
Too late. You already did.
That there were no x-rays taken of John's arm. He tried to...
You already did, Connor.
What did Connor do?
You can't leave. We got your link, bro. We'll just rejoin you.
Yeah.
Easy peasy.
Deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown.
When you docked with Dean, he downloaded all your information.
And Dr. Welcher wasn't going to admit it. And my goodness. Then we get to the sweatshirt. That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt. Not just to the witness, but to you. And asked Dr. Wolf about it multiple times. Specifically, while he's in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf. And Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole. Dramatically.
I got a feeling that TNUC is bad. Dean. It's probably directed at you.
I think it's you.
No, it's definitely directed at you.
I don't think so.
I think so.
It was clear what the suggestion was. That the holes in the back of John's sweatshirt were from January 29th.
No.
That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know.
Yes, Mary B. It sucks because I really want to give everybody their wrench back, but that literally could have been the spam. That could have been the whole thing, because I could have said the wrong thing while I gave somebody one I didn't know, and that is a scam for a like. So we will not be doing that again. Since they didn't tell me, I just have to fucking follow the fucking rules.
Their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Reed. The truth is, Karen Reed is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reed because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Reed, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Reed of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks. Yeah, the serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel, through your verdict, that justice cannot be bent and that it will not be buried. Find Karen Reed, not guilty, not guilty, not guilty. Thank you.
Powerful stuff.
Yep. It was good.
It was.
It was good. Now we'll move on to Hank. See if we can get him to finish up in an hour.
I think at 1.5 times speed, definitely.
Yeah, you should. Should.
Thank you. John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying. And he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance that he met the Isaac Wolf of the world, but to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child in the front yard. She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking McCarthy's with John. She was drinking at the waterfall. Her blood was taken with samples of the retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture. Count Coop, we heard all about it when the back of his head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you got to get help. You got to get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die. She was drunk. And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night, because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you when there was an argument, John would do what John does. He would walk away. She described to you one time, to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages. Now it's all lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. and they drink a lot. We drink a lot, and Karen Reed drinks a lot. You've seen my coffee videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the mixed drinks, more shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober. And then at the waterfall, a shot, a mixed drink. Now, it was brought up at the waterfall that there was some type of discord between Ryan Higgins and John O'Keefe. They knew each other. They were friends. Ryan Higgins' conduct of speaking to Karen Reed is not honorable. It's not. If they were friendly, there was no adversarial relationship. There was no anger between them. What we heard is they barely breathed each other. Can we have slide one, please? At the waterfall bar, when John O'Keefe coming, here's him barely greeting him. That's him. And Mr. Higgins. Barely greeting each other. Reality sometimes is different than argument. This is a celebratory move. Celebratory move. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In the celebratory mood, you don't see any aggravation or animus between Ryan Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that time.
And it takes probably about 5 or 6 or 4 different groups. Like they were more they had more these disparities in imposing alcohol. What's the weakest time? It tasted just like all soda water with wine.
Slide 3, please.
I wanted to on the expressway. I wanted to on the expressway. I mean, it's why the world with everybody in Seattle feels. And I followed the right, I think I'm saying right, those were results.
Is it? Did you pause it?
Yep.
Is it just me, or is it impossible to understand what she's saying?
It's probably because it's in 1.5 times speed. Maybe.
Okay. Yeah, I was like, dude, I have no idea what she's saying.
I wish it was impossible to hear what she's saying on those things because I think that's his best evidence,
Yeah.
to be honest.
Like, I know what it is, but it's like when they're playing it right here, and then we have it at 1.5 times speed. I have no clue what she's saying.
It's probably your cig kicking in, that nicotine.
Oh, you're right. I should go smoke.
Yeah, you need to. Better hurry up.
Don't. You gonna rush me?
What?
You gonna rush me?
Can't rush a cig.
Can't.
Not a what are you on, Virginia Slim 100s?
I think Virginia Slims only come in 100.
Yeah, well, the 120s then.
Yeah. But no, I smoke Marlboro.
Oh. Marlboro Reds or some weird black ice things.
No. I do smoke Reds, but I also smoke 27s.
27s?
Yeah.
Connor, we're right. Connor, we are right about Dean. He smokes 27s.
You think she drank when she got home? When they leave the waterfall bar at 12:12, you see a video you have in evidence with a still photo of John O'Keefe holding a glass. Not from the owner's home. He didn't sneak into the house in the cupboard and grab a glass. From the waterfall, you see him with a glass, and in it is a straw. Take a look at that picture. And now from 12:12 on, we virtually have a historian and the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher, took the data from the black box and downloaded it so you can see the movements in the children events. And then Shannon Burgess, you know, like he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV. But what he did is he found a key, critical piece of this case that did not exist before. He found a recent thing. It was that SD card, the SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the time and date and location coordinated for an impenetrable timeline that can't be broken. That's what Shannon Welcher did. And so we know on the way from the waterfall to 34 Fairview, Miss Reed is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said at the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze, high location data, as Ian Whiff would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement. And that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship. And then there's a trigger. There is a trigger on the way because they're lost. And when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Slide 4, please.
Very close to the Alberts. In fact, when Jen is navigating beyond to the Alberts when I was driving, she said it's near Ashley's house. Ashley and John are hooked up prior to John and I dating.
So they travel to 34 Fairview under the duress of this crumbling relationship, fueled by intoxication. We have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide, and it shows you with the healthcare data, it measures his flight's time, but it doesn't mean someone's climbing upstairs. What it means is there's an elevation, and he breaks down the data, the red, the green, if you can move down, he's going. And then the bottom left, that's 34 Fairview. You can see, second by second, the circles of their route, even the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar Crest. And because of Shannon Burgess, and because of Doug Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. It's a 3-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. DeSorter comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the board and made decisions like the Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds.
Dean, that's not me coughing. That's somebody in court. That's not me. Not me.
Same window, same time. We have all the arguments we want. They're there. They're together. The data matches up perfectly. Perfectly. And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for 2 reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest at that intersection before it goes down to the right. They meet. They let Karen Reed go first. They follow behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life. And he's in that car. He's in that car for most of it. Because Ms. Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. And they didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery.
Hey, Yellow. Everybody say hey to Yellow and River. Yellow and River.
Stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Ms. Mason and Ms. Nagel said they're there about 5 minutes and then they go. It's not exact, but about 5 minutes they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down. She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car. And we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves for 20 seconds. Ian Whitman said that the satellites, they move, they reconnect, they call information. He's no longer on high frequency data because waves are shut off. Now it's more random, it's low frequency. We would never suggest that Mr. Whitman did not claim, based on location data alone at that point, you can tell exactly what he is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he's always near the flagpole. He could have moved. He could have moved in the circle, come back. Location data is consistent with him never leaving the flagpole. But that in itself is not enough. But there's more. There is more. There is the healthcare data. There is the temperature of the cell phone battery. And so he moves for 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door from 75 feet? Could he get there? Because when we investigate for the defense testified, he measures from the driveway. He never stops at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data. 20 seconds of his life, and he moves. And healthcare data registers the steps. It could be pacing. It could be a straight line. It could be shaking the phone. We don't know. We don't know. We don't know everything. We don't know every little detail in every little second. We don't have to. That's not doubt. That's not reasonable doubt. We know for that 20 seconds he's moving, and in that 20-second window, when he moves, he has his phone and he looks down, 12:32:09, and sees a text message from his friend, John King. And he looks at the text message and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Lee, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. But like knocking on the door, like Kaylee said, getting the last word, she doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Ms. Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going.
Megan, she actually told the people in the ambulance that that was the last thing that they were doing was fighting. Just say.
To suggest or try to prove that Ms. Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove and what we have proven from the evidence in this case of second-degree murder is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and if that conduct would create a clear and plain likelihood of death, then she's guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy. If somebody, maybe a teen or someone young, impulsive, is on a bridge, and they see cars going by, and they have a boulder, and they want to throw the boulder off, they're not looking to hurt anybody. Not mean to kill anybody, but they throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder off the bridge, and it comes down and lands in the car, and there's somebody, passenger, anybody in that car, and it then goes through the roof and kills the person in the car, do they intend to kill that person? No, they were trying to have a thrill throwing it off. Do they have the malice to want that person dead? No. They didn't. But that would be an example of second-degree murder. When you take a boulder and throw it off a bridge, there's a plain and strong likelihood of death. When Karen Reed, in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him, and he died. I suggest to you that is second-degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol, and you drive a 6,000-pound Lexus in the heat of the moment, at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton, it is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene, knowingly causing death. And we'll get to that. So now, sadly, we need to get back to 34th Avenue Road where we left. We know from the tech stream data that she drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers the 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with them. This data doesn't tell you collision. It's a 6,000-pound Lexus. There's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when we reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever the disorder wants, he stops moving. He stops moving. Forever. Forever. Let's slide 6, please. We'll get to see this more closely. You can't probably see where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred for somebody to come back that hard, that fast, that reckless, that obvious, likely to create a pain and storm, likelihood of death. That data tells a story that can't be changed. They're attacked. Arca? They do some crash test on me. You know what else they do? Catching data. There's nothing about that data that is uncertain. Nothing. Take that down, please. When Ms. Reed hits John O'Keefe, collides with John O'Keefe. We don't know if he went in the air foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back. But we know there's a collision doubt. There's a collision because pretend it's all over the yard. It's all over the yard. And when he falls back and he hits the back of his head, his basal fracture, he's then lying there helpless. When Ms. Reed leaves, she leaves behind tons of her taillight. All over the yard. All over the yard. It's called debris field. And you've seen videos. You can't replicate the exact contact. You can't because you need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris field and a light is broken, it's no different than it was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry. You know she's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare factor 1231.6, 1232.04, 1232.12 is the data which is adjusted and reconciled with the Lexus. 1232.09 is when Mr. O'Keefe closes the phone after looking at Jen McCabe's text. 1232.16 is his last steps. When the short says that red range, you move a little bit 2 or 3 seconds, they can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. We have slide 10, please. Please. Okay. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car. Now, as John O'Keefe sadly laid on the ground, abandoned, you're going to have to ask yourself a question for charge of leaving scene, knowing somebody was injured and then died. You're going to have to ask yourself, is there evidence that Ms. Reed knew that she'd hit him? Don't need to prove it for murder, too. Don't need to prove it for OUI manslaughter. But for the third charge, Carmel has to be unreasonable doubt she knew she hit him. We weren't there, but there's an eyewitness. There was a guy. And that eyewitness tells us that she knew. An eyewitness. You can't read yourself. She tells you that she knew. We have slide 8, please.
Could I have hit him? Did I hit him?
Oh, yeah.
I don't know what that could have been. It's Holly Wind. I got YouTube working on the stereo. And did he somehow try grabbing down between the electrons over the bars, like so people in their heads? Did he come up in a trip or bend over the cell phone and I ran over his foot and he passed out drunk? I mean, I didn't think I hit him, but I clipped him.
When she left Fairview and left John behind, she didn't think he was mortally wounded. She knew she hit him. She knew she hit him. And so when she made her way back home, not only did she leave to Gleefield all of the front, but she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Gemma K. Please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please. You play voicemail on this? The calls keep coming. Cell phone temperature 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. They tell you the story. As this temperature plummets and that cell phone battery is compromised, so is John O'Keefe. And him and his cell phone alone on that yard. 66 degrees, 12:45. It is plummeting. Ian Wickens taking a phone and putting it in a freezer. Not the same analogy. The idea that means that John O'Keefe in the house absurd. 66 turns to 61 is 12:53. 48 unanswered calls from the defendant. He's not in a party. He's not wrestling with Brian Higgins. He's not in a fight. He's in a fight. His cell phone would be moving. There'll be healthcare data. There'll be steps. If he got into the house in 20 seconds, and his cell phone is found under his body the next day, and how would he get back outside? There would be more steps because his phone is working. The data is the data. There's nothing wrong with it. It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 2, please. Listen to this. Did you hear that? Nobody knows where you are. It is 12:50.
Oh,
That's dirty.
in honor of Dean being here, we're going to listen to Toy's new song. It's appropriate time.
In a town where whispers crawl through the dust, lies and badges crumble dry. She stands tall with fire in her eyes. The truth's a blade that never dies. Justice is coming, it won't be long. For every crooked note in their twisted song, their own brother betrayed, their lies will fall. Justice is coming for them all. They play their games behind locked doors, but she's got keys to their shadowed floors. Every secret they try to hide, she's got the light to burn their pride. Justice is coming, it won't be long. For every crooked note in their twisted song, their own brother betrayed, their lies will fall. Justice is coming for them all. Through the fear and the silence she walks alone, her voice a hammer breaking their stone. Their power's a tower but it's built on sand. She'll bring it down with her steady hand. Justice is coming, it won't be long. For every crooked note in their twisted soul, their own brother betrayed, their lies will fall. Justice
was a good one. Pretty good.
59. John O'Keefe has been on that lawn.
Yeah, she spends a lot more time on those things. Making like all the video and shit now.
Where is Toy?
She's lurking. Supposed to be coming to hang out before we get off of here. I know she can hear me. So she's messing. She's knee deep in the AI right now. Can't break herself away.
For about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are. She knows. She knows. Nobody does know where he is. She said, okay. Except her. Why is she asking nobody knows who you are? She is starting to get panicked. Because she knows she hit him. Not suggesting she's meant to kill him or for him to die, but she knows she hit him, and now he's not responding, and she's getting nervous, and she's getting anxious, and she's getting call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move after 1 o'clock. She could be sitting, she could be falling asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning. Take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, where's John? She doesn't call Brian Higgins. Has his number. He's been texting her. Hey, was John have a party with you? Did you see John tonight? She knows exactly where she is, and she's frantic. So she wakes up Kaylee, that young girl, crying. And she says, she's panicked. She can't say what she's saying. Call Jen McCabe. Call Jen McCabe. Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? When did he leave the house? What happened last night? No. She calls and says, I left him at the waterfall. I left him at the waterfall. See, now it's gone from penance to self-preservation. I left him at the waterfall. And Jen says, left him at the waterfall? I saw you in front of the house. Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Terry Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see. But someone's going to find him at some point. So she calls Terry Roberts. There's no one she left at the waterfall. She pivots. She calls Terry. John's dead. I think he got hit by a plow. Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus for another big vehicle. I think he got hit by a plow. And so now we have the introduction of John McCabe and Terry Roberts. Phone calls that they probably never, ever wanted. A worst nightmare to get a call like that. So what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night, in a blizzard, out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom, with a perfectly normal life, gets drawn into this whole farce, and she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Terry Roberts didn't know Jen McCabe. They both knew John. They met each other 1 2 years before. Terry Roberts separately at that time answers the call, gets out of bed, drives to go help because they have a common denominator, a common bond. John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and John Welch showed you all of those demonstrations where you can see the unsettled snow in the back. After the bump, you can see the piece is missing. No taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no brake. It's a nudge. It's a nudge. But the taillight has already been broken because when you look at the video, not one little piece that's full frame, little angle with the light, you take a look, you've got to slow it down. You'll see the exact same piece is missing. Because it's back to Fairview. That's why it's missing. It's not there, it's back to Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about 5:35. 28 minutes. It's about a 10-minute ride. Where did she go in 28 minutes? Where did she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down. Can't understand her. Going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had Lincoln's house on the couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere in the way behind? Did she just see death? Terry Roberts comes, take charge kind of person. She pulls him behind, she sees the broken taillight in Jen McCabe's driveway, and she decides she's going to accommodate this. We're going to the back to Meadows. You're going to follow me, leave the car, I'll drive. At this point, Jen and Terry don't know each other. They've only met once. And they go back to Meadows. They obviously don't find John. He's going to be back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Terry Roberts, Jen McCabe, they're looking out the window. They can't see anything. The snow, the blizzard, the weather, the darkness, they can't see anything. And they're driving, and they decide to go back to 34 Fairview. And this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close, they can see nothing. But the defendant screams, "Stop, let me out." And they look around and they say, "What? Let me out, let me out." She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him. She told us. Slide 13, please.
Charlie and Jen's in the passenger seat. And I described this to everyone, so you probably heard this before, but John like a buffalo on a prairie. It was just a lawn in a heap that it wasn't for a sharp hydrant or a dog. It was a weird shaped look at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you. A weird shaped one in a blizzard. You do equate that to John O'Keefe. A weird shaped one, not like a bush. And that is John O'Keefe.
Well, why doesn't he say a man in the snow? My best friend. My best friend, the man in the snow, the guy.
She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen. And she's upset, there's no doubt. I am not for second time to deprive her of the unrest and the trauma that was happening that he's seen. Doesn't seem to happen before, but I appreciate the trauma. And they're trying to help him. And that's what happens when they first move him around 603, 604. Being with him. Data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd. Hasn't moved. They start shaking him. You're going to see, when you look at the records, the healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. And she plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. Remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the other house. The glass, well, you'll hear in the clips. If we don't play, we'll have all the clips with you. It talks about the fact that he took the glass. He took the glass. She says it. So the outer house, they move the glass. Every house, the glass. With straw that's later found on the street, by the way. That's what happens when an impact things move. The glass comes with him. Lands in his body. The brief field moves past him. Shoe, hat, straw. Gemma Kay makes a call to her sister, and they say because it registered 29 seconds, a cell record is not the same as a call detail record. There's no evidence, it was a conversation, no lights go on, there's no conspiracy. You can call somebody, it can ring, it can go to voicemail. They have no evidence, none, that there's a conversation between Jen McKay, the person who was ripped out of her sleep, to come help, and her sister for some grand conspiracy. And so what happens next is dramatic. Kelly Roberts and Jen McKay see their best friend, prone, lifeless, frozen, on the ground. And they're living this torment because somebody brought them into this. When they're trying to help John, there is not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time has anybody said, what time did he leave? I thought he went in there. Not even a whisper of it because it never, ever happened. When they find their friend John, he's not 20 feet off the side of the road, like Mr. Ventura or Mr. Wolflix. He's right there by the side of the road, close by the third. We have slide 14, please. You can see the Terry Roberts in the middle, and then on the left, you can see that is a club. He stumbled and fall. Remember when he fell, it wasn't snow. It was just the beginning of the dusting. It was the cold, hard ground. Remember what Dr. Isaac Wolf told us about cold, hard ground? Causes second injury all the time. All the time. If we could go to slide 16, please. Remember the glass in the nose? The glass in the nose. See the glass? That's where it can't be part of the glass. And he's looking at it. I don't know about that. And then exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass. The glass was found with Mr. O'Keefe. He didn't fall back 8-10 feet from the road. It broke and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind, a trail to memorialize what happened to him that night. Remember the straw I asked you to take a look at that picture, the white ball 12, the black straw in the drink on the street. Collision, glass, nose, straw, back, this is it. You play the clip on the left, please.
So I got house. Each of them.
169, please.
So John's laying there, his left and his right, and I approach John from the left. That's what the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And it just pulled it. And as soon as I pulled it, it just gushed blood down his face.
Thank you. 911 called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics. Getting to work 2 hours early for no blizzard so they get there on time so you can help people. These are the core of our community. Mr. Nuttall, this is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody. But to him, it's another human being. This is his passion. Katie McLaughlin, first responder, this is not his profession, it's her life. Yes, she knows Caitlin Albert.
Mary B.
What's up?
I don't know what's up with your picture. I can't see.
Yeah, you're invisible.
I'm invisible?
Yeah.
Mhm.
I can see
Oh,
myself.
there you are.
There you are.
Just
There you are. You just came in as you got really close to the camera.
Yeah.
Oh, I can see now that I'm invisible. That's so weird. I can't see it on StreamYard, but I can see it on YouTube that I'm invisible.
Well, you were.
You
You
were.
are now.
I'm back for good now. I'm not like disappearing sometimes.
No.
No. Why do
Right.
you usually disappear sometimes?
No, but I mean, I was invisible, so
You
I
were.
have a little bit of a complex now. You know that I'm in chats and no one can see my chats, and then no one can see.
Nobody
picture.
looks better than they do when they're invisible.
That's true. That's true. I gotta smoke some weed. It's been a friggin' day.
Selling weed causes you to have to smoke weed.
Yeah, it does. It's crazy how that happens.
Somebody stress you out about terpenes or something?
No, people stressing me out because we don't have certain products that they want, and
Okay.
you know,
Why don't you have them? Just certain brands.
no, it's just we're slacking. I mean, it's not me. I have no control over that because if I did, then we would have the stuff. But I did sell weed to my mom today, which was fun.
Nice. Every kid's dream.
Right?
That's a unique experience.
Yeah. I like dealing with all my customers, and then my mom walks in. I'm like, "Hi, mom." They're like, "What?" That's so cool.
I saw it all in for a second, so we better try to get through this. Got 28 minutes left,
I got
which
this.
should be 14 minutes
You think she went there that night at a party and set up a murder and came back?
because I got Hank
So
on
they
high
tell
speed.
you, what happens at the scene. Some things hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes something you'll never ever forget. And Timothy Meadow remembers speaking to the defendant. I hit him. Memories on his knees. What happened? I hit him. I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him. She clipped him. She didn't think he was mortally wounded. She panicked. She can't come to terms with this. She wants to bring people with her to face it. And now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. I hit him. She speaks to Mr. McLaughlin. I hit him. When did I hit him? Could I hit him? Perhaps I hit him. That was earlier. Now she's recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer.
Mary B, we're all wearing our rat suits. You see that? Trying
Yeah,
to
I
get
like
Prince,
that.
trying to get Prince Lover hers. The toy's lost in AI. So I don't know if she's gonna make it. Time's flying. But you
Well,
should be able to
Prince
get
Lover
it.
has one in the song. You just gotta pause it and take a screenshot.
Yeah, Prince Lover's in the Discord now, so
Oh, okay, perfect.
should be able to get it to her.
Or a conspiracy. Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece of that piece. I know it doesn't reconcile with everybody setting up to go. I know it doesn't reconcile. But the reality is, you have independent core people who hear her say, I hit him. I hit him. And the attempt is to portray everybody as a liar. But you don't have to rely on some of these good people. Oh, you should. You should. You don't have to.
Gingy, are you saying that Mary B could have been the deceptive content?
I'm the reason that we got canceled.
Yeah. You have to start putting out or something.
Oh,
Can't
all
do it.
right.
Dean laughed like you're not taking my job.
Yeah, maybe we can just switch out like real quick. Like
That
I'll
was a
pretend
laugh.
to be, and then I'll like leave, and then you can come in and take care of everything.
So like a reverse Revenge of the Nerds
Yes.
situation.
Precisely.
I gotcha.
Oh, God. We're getting kicked off.
Next time I'll at least pretend that I would date him.
Yeah. That's,
Okay.
we're not really saying date him. Dean's the only person that meets people off the internet.
It's not true, Danny. We're gonna meet.
No, Petty does. And that's your holy grail for the rest of that. But
Danny and
Didn't
I
go
are
well.
gonna hang out next month.
What's
Aw,
happening then?
I have no clue, dude. We're hanging out, bro.
I foresee that next month may turn into the month after that.
one of those things.
But it's heading down the pipeline. We just don't know when. You know what I mean?
Hell yeah.
You know?
No, I don't.
You
I
don't.
heard.
Connor knows though.
I heard that.
Yeah, Connor's just sitting around in his house butt naked with socks on, chilling.
Wait, he said we were gonna move to Hawaii? Oh, I should have just said yes.
You turned that down?
Yeah.
Whatever.
Learning experience.
Because we have a guy.
Is what in the
Slide
chat?
17.
Symbols. Did I always say here, but did I really say as many times as Mark was cleaning and said it?
I know it doesn't fit the theme, but the story, but she tells you herself. She endorses those good people exactly what they have heard. She tells you herself. She hit it. It's undeniable. It's unmistakable. It's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no.
Now I'm curious. You see this, Dean?
Yeah, so I just in the chat I asked Gingy how her day was.
Uh-oh. This better be good.
Coincidence that Mr. Nuttall and Miss McLaughlin hear exactly that. She tells you. And Jen McCabe, when she's standing next to Miss McLaughlin, she tells you that she sort of heard the same thing. Remember what happened to her at the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, how it was going to see her best friend dead. What happened when she had the audacity to say that? And now we know that the friend herself said the same thing. And the funny thing, the ironic thing is, you will see in a photo when Miss McLaughlin, firefighter, was speaking to the defendant, Miss McCabe was nuts about it. Miss McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of the story was trying to help the defendant from incriminating herself. The irony. We have slide 9, please. This is the battery temperature. You didn't have a chance to look at it. If the lens are tragic, it is interesting. It is interesting. You are here. This one, 12:13. You'll need the white line. He leaves 122 in the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it started to go down 72, 12:45, 66, 12:53, 61, and you see it drop and steady up at 1:36. Remember, cell phone battery under John O'Keefe, either struggled with life or was fast, and life still warm either way. Under him. Doesn't move again until 6:06. It drops down 7 degrees because the woman up pulling on him, the cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it, still photos. Curry Roberts goes over, takes up the phone. Not only, this is her phone, she puts it in her pocket, and then 20 minutes later, the next meeting, the temperature rises. That's not convenient. That's not coincidence. That's fact. That's data. And then the ball is fast, but the one line and it raises up. 6:15. How can someone decide to pick up the phone on the side of the yard that's under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? Not only did the battery temperature rise, when you look at the healthcare data, at 6:15, when you pick up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes someone to die in a cold. And there's Miss McCabe in her winter jacket, soccer mom, trying to help. She has MS, her hands aren't working, she's trying to type in what's happening during that time. It's a frantic scene. She tells you that the defendant then wants to run back to the ambulance, so she goes with her and never finishes or completes the input. And then she tries it again. At 6:23, at 6:24. That's what this woman did that night, that morning. Not only for her friend, for her. For her. That's what she did. And what happens to her after? Because the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Pokemon Sports because she is so interested in kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that's being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. But she's not deleting anything. Just I told you, there's automatic deletions all the time. You can't delete that information. That's not like a swipe like what Dr. Wolf Marker knows how to do. This can't be erased. But they still hold on to this. As they argue to you all the injustices that have been done, they tell you, they want you to believe. They take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way. Don't look at her. Look the other way. 2:27. Look the other way. Don't look what she did. Former Trooper Proctor. Look the other way. Don't look at her. Every time they make those, oh, she got the in the basement. Look the other way. Don't look the other way. Look at the facts. Look at the data. And it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself. Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Try to evoke that primal reaction, discuss. I'm saying you should be expressed by your text messages. You should. They're not defensible. I don't stand here defending propriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper Lieutenant was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? He said it was integrity. They never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't. But that does not, it doesn't create a conspiracy, it doesn't invent a dog, it doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. If there's a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments. Not that there's any evidence of tampering, not that there's any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need Trooper Proctor to prove this case beyond a reasonable doubt. That's why I didn't use this evidence here. Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she was leaving the driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house inadvertently, they didn't even know it. The dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He's been near the car. And then the Dighton videos themselves. When you closely take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please? 507. You plan anything you want. Look at this angle. It's gone. We don't plan it. It's all way gone. You know where it is? Third, fourth, Fairview Road. On it, retail. There's 29, 2, 23. Look at the left-hand side. Look at the left-hand side. It's back to snow. It's gone. It's gone. And the same thing, when you do videos, it's an angle a little small, play that and watch the, let's go down and slow down, you'll see it expands. It's gone. So when you have Dighton Officer Barrows come in here and try to tell you what he saw the solid could have been it, you gotta ask yourself, what interest does he have coming in here in this case? A lot of attention on this case, a lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet the conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can convene to get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite. And so he sits on the stand with a new story after a meeting. We don't know why. But then I show him that bottom right photo with the snow, with it missing. And I say, is this the way it looked? And of course, we can snow melts out the solid part so that you can see it unexposed. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman. There's no plant. There's no picking to the salad board. There's no one tearing out pieces. In fact, remember I told you a clip, you'll have it, where the defendant says, I was picking up pieces that was crashed in the bubble showing when I was showing Terry and Jen, when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves, there's no ring video when she gets back. And so now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished, I respect that. She's the only dog expert in the world. Thing is, we have no idea what that expertise means. She volunteers for the job. She wants to be here. Profile, but she can't explain methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, and then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense is bragging about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are not punctures. Punctures mean it goes into the skin of a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yeah. After saying there's no punctures, Dr. Lapasada comes in, and she sees punctures everywhere. It's an animal attack, it's a dog. What is it? No method, no methodology, no history of this, no prior testimony that we know of other than how to tell you what she says. And she says the exact opposite. Dr. Russell, why is that? How does that happen? So obviously, there's no science to looking at an abrasion and saying where it came from. They give us no detail, they give us nothing that we should rely on, they contradict each other. It's just picture to look the other way. And so we have now the issue of the defense has said over and over again, there's no collision, there's no collision, there's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scotty Bella, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes, like that in the clothes. She knows nothing about that. So 90 days, she didn't see any low injuries. She didn't see any low injuries, which are very common in car collisions. But that doesn't mean it didn't happen because she in 90 days saw a fraction of the information, a fraction. And we know now, argument back and forth for days about lower body injuries. The suggestion is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some people get shot by a car, have no injuries. Some people.
Did y'all get kicked out?
No, it's I tried to comment through StreamYard and I recognize the icon. It's saying this comment has failed to post to Rat House Media, but the icon is a different DA Talks YouTube channel.
Oh, I see.
And that's weird.
Huh.
Super fucking weird.
That's the other DA Talks guy.
Yeah, it's like I think they're like DA Talks 1 or something. I recognize the icon from when I've looked up my channel.
Yeah, when I look it up, I see the other guy too.
Yeah, it says DT as the icon.
Yep.
Yeah, that's super weird. I have no idea why it's doing that, but so I've tried to refresh it and it's still doing it.
The apocalypse.
Yeah.
Will get touched lightly and have more injuries. And there was the debate about the lower body injuries. Well, ARCA dispelled that in the dummy test that you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time, in 90 days, that she doesn't have enough information to say consistent with a car accident doesn't mean it was a car accident. Let me talk a little bit about ARCA. I don't want to waste too much time with them. What expert was supposed to come to you? They're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you to explain what the left thesis is, so that it's clear for you so that you can make a decision. That's objectivity. The word like confirmation bias, objectivity. Just to work out on the stand. And before we even started, you have to ask yourself, what expert has a court order for text messages and deletes the text messages? What expert, what objective expert uses signal, and encrypted out to communicate about the case? Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8. That's all. And because the lighter arm takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic. And he fought me over and over again. Did he seem objective that he was trying to help you? Because Dr. Russell came in the next day and said, we have to adjust for that. That's all I asked him for an hour about adjusting, just so Judge Welcher adjusted. So you adjust it. And he tried to talk to me like I was making something up. His own colleague had to admit it. That's fine, he admitted it before he got to his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point. And speaking of sequestration, remember Dr. Russell on her little ride over? If Brendan asks you a question, make sure you also answer it. Improve the progress. Slow down the question. Interfere. Sequestration, that is just fundamental fairness for all witnesses, not just some. And so what happens to Dr. Russell? We don't know. But we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense. He said, no. And at the end of the examination, he did his transcript and it was yes. And he tells us that he's independent and effective. I asked him about lunch, and not a big deal. Just ask him about it. And he says, I have a sandwich, I stand in the corner until I remind him that we got video footage from a documentarian, and he's in one of the scenes. And then things change. So when you talk about objectivity, if they can come in and say, Judge Welcher said this and that, it doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is.
Lawleen was up here. She must have got a phone call or something. This is what Sweet Woman was doing today. Headed to the Cape.
Oh, is that the Sagamore or the Bourne Bridge? Let's see her drive. I'll see which one it is.
I don't think it's a video.
Oh, I thought it was a video. I always take a video going over the bridge too. It's probably Sagamore. That's how you get to most places.
Yeah. While we got it paused, I'll just show everybody their chat rat.
Yeah.
Let's see. This is the newest one. I hadn't seen it. I was too distraught 4 days ago.
Oh, no.
True crime chat rats. Let's go. Puff past true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rat pack. With my rats chatting about the crimes, the players and the evidence. Where it all went bad. Taking all the facts. And we bring them to the chat rats. True crime social where we be every night, doing everything we do for the truth. With my rats chatting about the crimes, the players and the evidence. Like it all went bad. Taking all the facts, and we bring them to the chat rats. All my people on the internet, all my people from around the world, gonna take you to the place we know best. Cause we're coming through like that. Puff mass, true crime chat rats. All across the world we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rat pack. With my rats chatting about the crimes, the players and the evidence. Where it all went bad. taking all the facts, and we bring them to the ChatRats. Puff, pass through crowd, ChatRats. All across the world, we coming through like that. Taking all the facts, put them in the trap, cause we coming through like that.
There's Toy. Great job.
Yeah, that was really good.
Yeah, but it all says True Crime Social. But that's fine because we gotta like save that because that's the original. You know?
Oh yeah, we're not gonna get rid of it. We're not gonna get rid of it for sure. Just gonna tweak these names till we find the one that we like. But I put those names in because I didn't really think it was gonna let me even do it. Probably talking about it on here is probably not the best thing either.
Yeah, who knows, dude?
Talk about what? I don't know what you're talking about, Mary B.
They
Do
got
you know,
Danny.
Ben? I don't know.
Danny's so shook right now.
I know. Like I don't know what the rules could possibly be. They could be anything.
It's like
I
that
know, that's why
episode of
we're
It's
gonna
Always Sunny. What are the rules?
We're gonna fucking follow them all this time.
Yeah, but we don't even know what they are.
I do.
Like I don't know what to follow.
Anybody can read the. I don't want to say all those key words.
He's like looking over his shoulder.
We'll talk about it later.
Jesus. In Discord, we'll post whatever it is that people need to read.
Yeah.
Okay. That sounds good.
Computers are smart, you know?
He's like trying to appease the YouTube overlords.
Your
computers are smart, guys.
You are the smartest.
Yeah, we have to give our youngest rat to him once a month to stay alive. So I don't know who that is. We'll just draw straws. Somebody's got to eat.
I think it's Cherry.
I think it's Cherry.
Mm-hmm.
But that just means I'm up next after Cherry.
How old is Clerk? Might be Clerk.
No, turns out we talked about it. Turns out Clerk is I don't want to say his age.
Yeah,
I just
don't say his age because you know how he is.
The youngest.
Yeah,
like, where are you from?
He's not
like,
the youngest.
America. Yeah. Remember we asked him like, where are you from? He's like, somewhere in America.
And then I got his social started. Yeah.
Like, what? We don't even know if he's on the mainland. He just said he's part of the 52. He's part of the 52. Don't look for me. I'm not here. That's why he has a wrench, so we can keep up with him.
Yeah, exactly.
But we need to get some stuff together where he can be posting in the chat. Cherry needs to train him. Gotta be posting.
Yeah, get those little what do you call them? Templates or whatever, scripts. And just
you can just make them, can't you, and save them?
I mean, yeah, that's what I'm saying. It's a script, and you just copy and paste.
Mm-hmm. That's it. Listen to Mary B.
No, it's not who acts the youngest, Connor. It's
so everybody's good at it now, but they weren't good at it when it mattered. Dean.
Yeah. I'm just worried because I'm second up. You know what I mean? Like, we're going to be sacrificing youngest.
I was hoping that it would be you as first up, but so we're going to swap.
Maybe if someone has babies.
No, I don't want to give.
Are you going to sacrifice like kids?
Jesus, Mary.
That is Mary B.
Trying to show whether or not the orientation could this happen with the angle, with the height. That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't. I'm going to show you why it's not that. Therefore, we win. That's all that is. It's semantics. Fred Welcher, Dr. Welcher, never suggested that in his work on texturing data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a question. We have, inevitably, proof, without any doubt, that on January 29, 2022, Miss Reed was with Miss O'Keefe, and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. There was a relationship in decline, and he got out of the car, and he had a brief window of life left. And when he got out, and she drove away. She couldn't let it go. She get drunk. She hit him. She left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injuries? Red slide 19, please. You bet they can. We don't know if this is the body position. We don't know if this is the exact speed where it tells us. This is vital. Look at the refill. Look at his turn. Remember to sneak up on that curve like a launch against the ceiling. The showpiece then falls back. Hits his head. Count the coup. Left to die. Thank you. Ladies and gentlemen.
Lolene, what happened to you?
Had a phone call, plus storms are moving in and out. Like, it's been pretty crazy this afternoon.
Yeah, it got bad here a little while ago.
And you got about 2 more coming your way.
It's been nice here all day.
It missed you because I know it hit in Tyler and then hit here.
I think it was like early yesterday and the day before, but today was nice.
Yeah, because yesterday was pretty here. We were able to get in the pool and stuff, but today it's been one after another coming through. But how's everybody?
Good.
Well, it would be better if Mary B would quit. with her
Everyone's
antics.
blaming me for what happened.
Well,
Wait,
you tried to sacrifice
but
children. You were like,
Wait,
know,
what happened with children?
Oh, no, can't. No. Back to
No,
Hank.
there's no doubt.
talk
That
about it.
night, there's no doubt.
Okay.
You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Straight, it is a plain and strong likelihood of death. You would never get back down the driveway, particularly at the end of the driveway. You say, well, you're going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. Oh, you had manslaughter, she's drunk, she was reckless. She doesn't even know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not an it. John O'Keefe is not a body. John O'Keefe is not a buffalo on a prairie. John O'Keefe is a person. And he was murdered by Karen Reed.
All right, juries, the next step is my instructions to you on the law. I'm not going to do that right now. You've been sitting for a long time. So I do have to tell you, even though you just heard the closing argument, you cannot discuss this case even with each other. All right, so we'll send you back to.
I kind of want to keep going.
with the what?
You're not going to ride turtles?
Yeah, but I'd like to get 3 hours in.
All
I
right.
can always rewind Turtle Boy. No big deal.
But I do want to go to Turtle Boy at the same time. But
Dean, I changed my picture and name at your suggestion.
Nice.
Now my name is Laleen and I'm a rat. There you go.
Hell yeah.
Yes, I think that's what Gingy meant to say, that I turned him down and that's the reason that stuff happened.
Definitely wasn't me. No men trying to get me into their schedule. That's all Mary B.
yeah, that was deceptive content.
We advertised her as having a weekly service and then she turned him down.
We said Friday was open, and Mary B said no, Friday's not open.
What I said, I did say, oh, I can't be put into a cage or something like that. One of those stupid things I said.
I thought you said something like you couldn't fit anybody else in right now. Maybe after the trial or something like that.
Yeah, that's also something I would say.
So, despite all your rage, you're not
Still
just a rat in a cage?
You are or you aren't?
I'm not.
Yeah.
Did Dean
I'm
make
okay
a
with
Smashing Pumpkins reference from the 90s and he's never heard of anything else from the 90s?
Oh,
I
he's
don't
heard
think
of
you
Smashing
realize-
Pumpkins.
Yeah, I know that song. It's a good
Oh,
song.
All right.
That's a great album.
I don't know the
He was
album. I just
obsessed.
know the song.
He was obsessed with pumpkins as a kid.
Bullet with Butterfly Wings. But the
No,
whole
it wasn't
album was
anything
the
to do with
melancholy and the
butterfly.
infinite sadness.
His
It
mom
was a
found
double
all
album.
these. His mom found all these pumpkins with holes cut in them, but they weren't in the shape of they weren't not in the shape of eyes. You know what I mean? Like, Dean, son, your pumpkin's eyes are a little too round.
They're just right.
What are you sticking through there? Pencils?
Hi, I'm back.
Oh,
I couldn't deal with like everyone else having their rat picture and like me being the different one. I need everything to be the same.
yeah. And Toy's here now, so everybody can. Prince Lover, we got to get Prince Lover her rat so she can change it. Toy, she's upset.
She just has to go to Toy's video and screenshot herself. I figured it out. She can do it. Have faith.
Yeah, that's what I did.
Yeah, you could just. Toy's got them all right there. She's been messing with all of them, so they keep evolving. So everybody's rats keep getting better and better.
Evolving rat.
Except for Dean's. I'm not letting Dean evolve. Stuck with that one.
Sweet woman, they were talking about Bullet with Butterfly Wings and say, despite all my rage, I'm still just a rat in a cage by Smashing Pumpkins.
Oh, that's what he says.
Yeah, despite all my rage.
It's such a great video, too.
I just thought it was like Ready to Cage, even though that doesn't mean anything, but
so
like,
all this time since
so I just made that
for
up.
30 years you've been singing this song in the car.
Yeah, you want to know another one I just figured out too?
You've been singing it completely wrong.
This is my favorite. I love The Doors. And I
Oh,
just
God,
realized
I'm going to kick you off here.
Are you not Mojo Rising? What were you saying?
No, I thought
Oh, God, don't
said,
go there.
I didn't know he said light my fire. Like,
Oh my God.
And no,
it was
I
the
knew he
name
said
of
light my
the
fire,
song.
but he says something about a funeral pyre. And I didn't know what a funeral pyre was until I
Pyre. Yeah.
Yeah. And I don't know what I don't remember what I thought he said there, but I remember like I was watching Game of Thrones or something and there was like a funeral pyre and I was like, oh, that's what he's saying. So then I, now
have you seen those videos about the people singing the wrong lyrics to the music?
Yeah. Yeah, those are hilarious. It was even
And
in
I
a
can
movie
relate.
I saw recently where like the husband's biggest thing about his wife was she was always singing, but always singing the wrong lyrics. And he was like in therapy and he had to start accepting her singing the wrong lyrics and stuff.
Yeah.
There's that. Sorry.
No, go on.
There's that one commercial. It was like early 2000s cell phone commercial, and it was Rock the Casbah, but the person singing Rock the Cat Box. Does anybody remember that commercial?
I don't remember the cell phone commercial, but I know the Rock the Cash Boss song.
Yes. I think, I heard the commercial first. And then I heard the song and I was like, oh, it's a real song. Like
Bill Murray even did a movie about that recently.
Prince Lover, if you know how to use Discord, they just posted it in there for you. You got your rat. You just got to go get it.
Go get it.
Download the picture, then go into StreamYard or Discord, wherever you're trying to change it, and upload it as your profile pic.
Yep. All right, let's see what she says. I have not watched this at all.
Oh, the jury.
I'm going to give you the instructions now in the law. But first, I want to thank you for serving on this jury. And
yeah,
you're going to put everybody to sleep here.
I didn't watch this. I was watching Betero, and Betero's like, I ain't watching that.
Well, we're watching it because it puts people to sleep.
She did no better this time than last year with explaining everything. It's still just as confusing, and the verdict slip is still just as confusing. Yes.
She didn't learn anything.
Friggin' chance.
She didn't
Count
learn
2
anything.
has 7 guilty options and 1 not guilty. And they requested just put not guilty next to every guilty. And she's like, do you have any case law for that? Like, no, but it makes sense.
Let's see.
for being so attentive.
It's not going to I already feel confused just starting it.
You'll soon deliberate for the purpose of reaching a verdict, but before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case. The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law. That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part 1 of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explained it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard in this courtroom, and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case. You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answers to the questions and the exhibits are evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and the surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use
and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done
Sounds like her gummies kicked in.
simply to help
Or White Claws.
you
Ah, a little poop.
understand the evidence, and you may consider it in your deliberations.
It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. You should evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for this purpose. Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability, and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact John O'Keefe, Ms. Reed, Michael Proctor, Brian Higgins, or others alleged to have authored or created them. If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case. Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it. Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinions witnesses.
It's kind of crazy to see all of those profile pics in the chat. It's just crazy. Connor's about worse than I used to be about changing damn profile pics. That's the third one I've seen him have. Oh, and Lawlene still got hers on. She got her face on.
Wow.
Change it on YouTube.
That's cold. That's cold. Cold-blooded.
After all the hard work Toy went through. that is shameful.
It is cool though to see all them rats out there.
Yeah.
Yeah, it is pretty cool.
And Prince Lover. Prince Lover. She hadn't really gotten hers yet, I don't think.
I think MJ tagged her in the Discord with the screenshot of it.
Just got to get in Discord.
She's in the Discord.
She's in there. She got in.
Oh, okay. I'm behind.
Yeah.
I see it now.
Mm-hmm.
All these freaking messages, guys.
It's active. We active.
Everybody stop
Thank you so
messaging
much.
Mary B, please.
What?
I said everybody stop messaging you, please. You're tired of it.
I know. Well, I see the problem is that I turned off the notifications and now I don't get the notifications when like you're going live or anything. So like I'm so behind on everything.
You
So
don't
I'm
got notifications on YouTube?
no. Well,
It probably wouldn't notify you.
She's
Anyway.
like, I'm not even subscribed, sucker.
no, I definitely have the notifications on. I didn't get one, I don't think.
Yeah, YouTube really sucks at doing
Yeah.
that.
It's like maybe we'll give it out.
Yeah.
Yeah, it ain't no big deal.
The weird one is when like you get notifications for like a live stream that happened like days ago.
Yeah,
right?
It happens all the time. I was riding in the work van, and the guy that I ride with, he would subscribe to the last page, and we were riding. His phone ding. He looked at it and he said, "So you're live?" Dude, I can't be live right now. I'm in the damn truck with you.
I don't think so.
But he was confused. He was like, "Are you live right now? Like, what are you talking about?"
But go live.
Like I'm alive right now.
Exactly. But it was like 2 days ago. Well, 2 days prior to when that occurred.
My YouTube
Allegedly
doesn't give me
occurred.
old notifications. My Facebook does. Like it's a new Facebook post, and I look, and it was like 3 days ago. So I don't know what's up
we're
with
not
that.
we're not getting off of here until Prince Lover changes her damn picture. We may be streaming forever.
May have had to testify in a certain way. You may also consider the witness's level of experience and training and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe.
Dean, I'd like for you to know that I'm still upset about you tricking me into something that we can't talk about here. But you fucking tricked me into it.
What an exhibit purports to show, and how much weight, if any, to give the exhibit. Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the underlying evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door of the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that's sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify.
Oh, nice. So we can, we can call this shit quits, huh?
Yeah, it's over. She changed her
Over.
picture.
She fucking did it, guys. It's awesome.
Dean's dying to get out of here, huh?
No, he just said,
Well, yeah, she
we're
changed
not
it. Let's
ending
go, let's
it. We're not ending it till she changes it. And
She
then
wasn't here.
changed it.
She wasn't here earlier when we were talking about that. You know what I mean?
No.
Now,
What do you
if
mean?
Little Miss were to pop on and we had to wait for her, then we could go a couple more hours. I'm
Does
joking.
she
gotta
She
wait.
even know
probably
about
has it
the?
down very quickly now.
Does she even know about the new channel?
She's
Ooh.
not very good in Discord.
I don't know. That's a Danny question.
Danny, does she know about the new
Posted
channel?
it on Discord. What more can I do?
Danny.
Send her.
You've got to specifically DM her with the new link, Danny.
I'll
Well,
send
when
her
we
a
find her in
telegram.
the chat, we'll let her know to go look at Discord.
Wait.
Telling her to go look at Discord is like you're about to spend the next 5 hours of your life sifting through messages for one thing. It's
Well,
gonna have
if
to
you
be
send it
pointed
in a
out.
direct message.
Yeah. Send the new link in DMs to her.
Yeah.
I posted it in the Discord.
Danny.
There's 752 messages in every thread in Discord.
Not in mine.
Just when
Why?
you get meme happy, yours gets that high.
What are you
Oh.
deleting them?
Miss Lover got her new suit. Yeah. Everybody looks different as a rat. But this is Being Trouble's new video. I wanted to watch it, but I forgot.
Ooh.
But we're gonna watch it. So trying to hit 3 hours. We're pretty close. This is only 15 minutes. It should be pretty good.
Microdot
It's the-
has the new one out too.
Ooh.
And so does
Yeah.
Joe Flipperhead.
Yeah, we are not playing any more of their shit. They have copyright music in there. Joe
No
Flipper
music.
got us a
Unless
strike.
it's our music.
Yeah, we got a copyright strike off of that. I'm not doing that again. Because I don't know that contributed, but they all contribute. You can add them up real quick, and you'll be like, me. What?
What was that sound again?
Bing, bing. What it sounded like on this end. Made a little
You
noise.
big truck.
Then, yeah, something like that. It doesn't tell you shit.
Go toward the passenger side of the car and outward. They go back and downward. And then Randy's going to get another hit in the elbow.
Oh, Randy.
And
Look
look at taillight damages from Arca's
I feel like
test
that whole
and
part
my
is Alan's
test,
closing about
and
the
see how much
diffusers because
damage
of being in
it-
trouble.
Yeah, could be.
the taillight
I mean, they didn't
actually
bring any experts
sustains.
up to talk about it. I mean,
This
he
is a
talked about the
direct
diffuser,
elbow
but he
and
didn't
arm
talk
hit
about
at
the light.
24.
He talked about the internal components not being broken, but he didn't explain what the internal components did, talking about Wolf. But
Yeah,
in
but it's the
closing,
jury. It
talked
really
about-
mattered to them. They showed them them pictures. That's what they needed.
I'm just
Alan
saying, like,
Jackson
I
grants
think
the
about
software
talking
admit-
about how the diffuser, if it's broken, you would have no light. That didn't come into the closing argument. It wasn't brought in during Wolf's testimony. So I feel like Be in Trouble might have contributed to that.
Maybe I haven't watched this yet. We're gonna find out.
4 miles per hour. Watch the taillight pieces. They go straight back about 15 feet, straight to the ground, following the vehicle. They do not go toward the passenger side of the car and outward. They go back and downward.
It's a good point.
And then Randy's going to get another hit in the elbow. And boom. You can see the pieces fall directly to the ground and back, following the direction.
And yes, Toy made a rescue Randy rat.
Oh, that's awesome.
That's
So
funny.
Randy has his own rat.
Of travel of the vehicle. There's a direct impact with the arm. Watch the arm. It's going to whip the body around. The taillight pieces are going to fly back and toward the ground, not toward the right side of the vehicle or passenger side, but straight back into the ground. The body's going to spin and would have fallen down.
Video or in this picture.
So this is a overall photograph depicting the taillights
I'm
subsequent
surprised
to this
Alan didn't
test
bring
at
up the
24
Jeep
miles
in his
per hour.
closing.
I will note that there is a taillight, and then there is damage to the quarter panel taillight.
Is there any damage to the internal diffusers on this taillight?
So if I go to the next photograph, if I may.
Please.
So you can see here, there is this kind of thicker, it's actually not a crack. So I'm looking at the clear diffuser here with the dots that you see. This line that you see, kind of opaque. I don't know if you've got a laser pointer to. So
They didn't broke out the damn cap.
line right here that's part of the assembly. So that's just a part of how the plastic is molded. There's a very small crack right here in the underlying diffuser, but all of the remaining part of the diffuser in terms of this portion here and here are all intact, and same with this portion of it.
What about the chrome piece that's running between the diffusers?
I don't believe that was damaged during this test, no.
And what do you know? Inside of the taillight lens is an actual piece of the taillight. If you look closely in the circle, it is a piece inside of the taillight.
What is this depicting?
So this is a photograph depicting the quarter panel taillight subsequent to the 24-mile-an-hour impact test with the ATD arm compared to that of the subject taillight.
Based on this test, were you able to reach any opinions and conclusions as to whether the damage to the subject taillight is consistent with striking John O'Keefe's arm at 24 miles an hour?
Based upon the test results, it's inconsistent with striking an arm.
This is dumb.
If you notice, this is a different test. This isn't the one we always watch.
Yep.
He's got a little piece of the lift gate hooked to this, and I think and it's a new arm. I don't know what that sound was.
Hopefully the camera caught that.
Well, none of the tests being trouble nor ARCA did resulted in 47 pieces. Like, that's what's ridiculous.
3 big pieces. 4th big piece. No clear plastic, no diffuser. No inner parts of it whatsoever. The arm is still intact. We'll examine that in a second. The car hasn't moved since it stopped. That is exactly what it did to the taillight. That was exactly 25 miles per hour. It put a little dent beside the taillight where the wrist bone hit. I would assume I'll have to go back and check the replay. That was 25 miles an hour. Lexus taillight with an 11-pound human arm. I would say it's a replica of a 6 foot, maybe 6'1", 200-pound man. And all I got was 4 pieces of taillight. This is all 4 of them. But if you think that blows your mind, let's see how bad the arm's broken, because I know the arm's broke. 2 bones right below the elbow. See how the arm's dangling now?
Depicting the damage to the liftgate taillight as well as the quarter panel taillight.
And what do you note in terms of that damage?
So on the liftgate taillight, a significant portion of that thick 5 millimeter red outer lens is fractured and broken off. The underlying diffusers are still in place. There was a small crack in, I believe it was the upper diffuser here. The quarter panel taillight had the clear section damaged with the outer lens missing, along with some fragments from the outer portion of the red part of the lens.
Next slide, please. What are we looking at in this slide?
So this is another photograph depicting the quarter panel taillight. As I indicated, there is portions of the red lens cover missing. The interior diffusers remained largely intact in this test.
Next slide.
This is showing the results of the 29 mile per hour impact test to the test vehicle compared to that of the subject taillight.
Given that orientation of test D, were you able to reach any opinions or conclusions as to whether or not the damage to the subject taillight is consistent with striking an arm at 29 miles per hour?
It was inconsistent.
What's the basis for that opinion, Dr. Wolf?
The results of this test.
Dean,
Yo,
it just hit me. If we could get Hen to come in here with all these with all these people with their rat profile pics and shit. Oh my gosh, she would flip out. She would flip
send her
out.
the link.
No.
Was this strike more
Yeah, it's busy this weekend.
reflective of
Oh yeah, that's right.
what you were attempting to replicate?
Jeez.
Yes, this was a more central impact to the arm.
So here we go with the super slow motion, 29 mile per hour hit. You can see the taillight's going to make contact with the arm. The arm's going to go flying. But as soon as it makes contact, right there, the elbow and forearm would have been broken and the arm goes flying. But look at the taillight pieces. They stay traveling with the vehicle. They are still going back at the same speed.
So this is a high speed or slow motion video depicting the test D at 29 miles per hour, just a different perspective than the previous video.
Okay.
Here's the same test at 29 miles per hour. The vehicle is going to make contact with the arm. The arm's going to get broken for sure, but it's going to also damage the liftgate taillight and the quarter panel taillight. But the arm in this test would have been severely damaged, well beyond what Buddy's arm was damaged, because that is a solid impact. Look how it bends. It would have bent the arm pretty much the wrong way for a human body. But it still didn't leave bite marks.
So this is extracted frames from the high speed video. So starting out left to right, this is roughly a first contact with the majority of the hand, the hand, the majority of the forearm in contact with the liftgate taillight, with a portion of the elbow in contact with the quarter panel taillight.
Can I?
That was it. It didn't break any of the diffusers. Didn't break the reverse light. Would arm do that? No way. There's no way. Absolutely no way. I'm going to do some further destruction testing to it tomorrow or tomorrow night, maybe Monday. But that would have been like several.
So these are photographs depicting the sweatshirt or hoodie that Mr. John O'Keefe was wearing on the night of the alleged incident.
And what was the role that this played in your analysis ultimately?
Well, so one of the things that I noted, and I can go to the next slide, is there were a series of small punctures or holes in the sleeve, on the right sleeve of the sweatshirt in varying sizes. I think some as small as just a few millimeters. Again, I think there was maybe 10 or 12, I think I recall, on the right sleeve of that sweatshirt.
Can you count those for us, please?
On the photograph on the right, I believe I see a total of 9.
And what about the photograph on the left, just the right sleeve area?
9 as well.
If you look closely at the holes, they're all, except for one, in doubles. And the one that has 3 holes is on the elbow. And that's probably because he had his arm bent and was pulling his arm away, and the dog got another bite in. Neither my test or ARCA's test had any holes in the sweatshirt whatsoever. None. It's because the taillight cannot cut and put puncture holes in the sweatshirt. Just cannot happen.
What are the arrows pointing to in these photographs?
So this is basically the previous shot, but what appears to be close-ups of some of those evidence markers.
You indicated some of the sizes. What were some of the smaller sizes of those defects or holes?
From what I recall, like I said, I think it was around 3 to 5 millimeters, maybe some of the smaller ones.
How big is 3 millimeters in inches?
It'd be probably around like an 1/8 of an inch or so.
For all of us that live in snow country, knows when you drive your vehicle in the snow and the salt, what happens and what gets on the back of your car. I'll give you a little hint. It's little circles of dried salt, calcium chloride, salt brine. When you live in a snow climate, right before a storm, they coat the streets with salt. And then every time a snowplow goes through, they put even more salt on the road. And when you drive in snow, the wind that goes around your vehicle, underneath it and over it, it creates a vortice in the back of your vehicle. It's kind of like a vacuum cleaner. It sucks the snow up and it deposits the snow onto the back of your vehicle. I'm not talking just a little area. The snow actually coats the whole back of your car. Every nook and cranny gets salt in it, and water, and ice, snow. And when that stuff dries, it leaves those little circles of salt. Just like right here. Now, Karen's vehicle has salt spots all over it, all over the windows, all over the paint, all over everything. Look at the water spots. They're all over her car, except for the inside of the taillight. That is impossible. It cannot be that way. There's no way. Where are the water spots? There is no water spots at all inside of the taillight. That is impossible. Impossible. That cannot happen. There's only one way.
Dean, did you teach him how to read?
I would first have to know how to read. Can't teach what you don't know.
Maybe someday.
We're gonna
Maybe.
replay that live. Was that on yours or was that on Raptors?
It was mine.
Nice. Then it would be easy to find.
And then do it in slow-mo.
No. We're gonna do it at 2 times speed.
Way that is missing. The lens was on it in the Sally port.
It was in there for sure.
I was in there. In you.
Like swimwear. I'm sorry.
God. It wasn't you this time.
I thought you were
No.
funny, Mary B.
Thank you.
You're welcome.
I just try everything, and sometimes some things are funny.
These
Like,
freaking profile pics are awesome.
Yeah, they are.
Let's see what all Mary B's got going on in hers.
So do y'all think that Jackson didn't bring up Higgins's Jeep in closing because of the Nagel and his ex-girlfriend's testimony? Since basically 2 people said they didn't see it and Jen said she did.
Yeah, I think that he was just trying to keep it simple, and that was one of those like details that didn't get brought up too much. I did? Oh, shoot. I'm sorry. Maybe I need to back off my microphone.
No, it's all right. Usually, I mean, you're not on. You may have just picked it up, put it, because I can hear you messing with it.
Oh, okay.
Every time you touch it, we can hear that.
I didn't touch
me and Dean probably can
Hear what?
hear every time she picks up her microphone off the desk.
Hear what?
Every time she picks up her microphone off the desk.
I don't pick it up off the desk, though.
Okay. So we're playing pretend too.
Maybe the cat bumps into it or something.
Oh, maybe I don't think I picked it up at all today, but
But yeah, that,
Huh?
that sound.
Okay.
That's the sound.
All right. I'm not going to touch it. I'm going to make it stick there.
Yeah. Going back to my rat. Way better looking.
I know. It's going to make things a lot easier. I don't have to try to look pretty.
I do like the rat icons. They're super dope. Toy, you're the best. I
Yeah, you
got
are.
2. I got 2 of these bad boys. Check this out. Blam. Now I'm in a crop top.
Oh.
Now I'm in a hoodie.
You got the summer and winter chat, right?
Fuck yeah.
Oh God.
He needs a runway wrap now. One he can
Runway wrap.
walk the runway with.
I need one of me in a Red Lobster bathroom.
Totally.
Oh God. That's hilarious. Oh, we lost somebody. There she is.
Oh, there she is.
I couldn't hear anything after I asked about the Jeep. I don't know what happened.
Mary B said she thinks he was just trying to keep it simple and it wasn't something that was brought up very much.
Oh, you listen.
Hell yeah.
I just thought it was strong testimony for Welter to say if something would have been parked behind her, she would have run into it. But like I said, I don't know if y'all heard me, but last trial, 3 people testified it was there, 3 people testified it wasn't. This trial, 2 testified it wasn't there, and only 1 testified it was. So I figured that might be the reason they didn't mention it.
Yeah, I agree with that.
That makes sense. Crop top.
Frogs in the pool.
Uh,
They're just
I don't know
waiting
what
to
is on
attack.
the plate in front of me. I'm trying to
Sweet.
figure that out.
Can we enlarge
Oh, it's sweet.
Mary B?
Nugs.
Mine
sorry,
has
what?
tons of detail in it. Like, I felt like I shared way too much with y'all after I saw what Toy made for my avatar. I'm on my cell phone. There's frogs. There's Louisiana. There's DNA. The only thing is there's coffee instead of wine. So
Oh, well, we'll have to change that. I also don't drink coffee. I have Monster, but that's still cool.
I mean, I would drink coffee, but I don't at night while we're on the lives.
Oh, my little Fiona. I love that.
Yeah, that's sweet.
My little baby.
Well, we made her 3 hours. Let's see what happens.
How long did Toy spend making all those? I mean,
Yeah,
I know she
couple
did
of
them a couple
days.
of different times. Yeah, like that's really
You take-
cool.
You have to type. The more detailed you are about what you put in there, I guess, the more detail you get back out of it.
Yep. It's so fun.
It was well worth it, Toy. You did awesome.
Yeah,
Thanks
there's
for our rats.
Where is
Now we
Janine at? I'm just sitting here thinking about her and her Metallica shirt. Where's she at?
She got a new one too.
Oh,
She got a new one.
I don't know.
Okay.
I saw her in Discord earlier today. I mean,
Oh.
just posting, but
well, now we can go do the rat raid because we're all rats in our profile picture.
we're gonna do chat rat raid. What is it?
Yeah,
Rat
don't
House
get us
Media.
don't get us kicked out.
Don't say Rat House Media, just chat rat raid.
Can we not say raid?
I don't. Yeah, you can do whatever you want. You're adults. I don't care.
dude, Danny's just expecting that like YouTube agents are gonna come up behind him, put like a
Parachute,
plastic bag
yeah.
thing over his head, and then like throw him in the back of a van.
Yeah.
Like Carolina Trooper's gonna transport him on his jet to his house, and they're gonna like fall down and parachute down in Mississippi.
He's gonna get waterboarded
Or
by
worse,
YouTube.
it'd be like Dexter and sneak up behind me and stick me with a needle.
Oh yeah.
Is that
That's
really
it.
worse though? Like I think I'd
Oh
rather
yeah.
that.
Anything with a
Well,
needle.
it is when you wake up and
Yeah,
you're
and you're saran wrapped to a fucking
right.
table.
Yeah, but the needle would be the worst part.
You don't like needles?
Oh yeah, I love them.
I don't think that's the worst part. He like cuts you open, right? Like
Yeah.
Yeah.
Doesn't he?
Are you like awake but can't move or something?
yeah, exactly.
I
Well,
didn't watch
he does-
Dexter.
he stabs them in the chest first, so I think that kills them. So
We're
that they
kicking
don't
Mary B off of here.
I'm sorry.
Yeah, that's like way worse than a needle. That's like a giant misshapen needle right through.
And he like yells at you and gives you like a lecture first, and
We need.
Yeah, I don't
Janine
want to
here
be awake
do
for my
disclaimers
torture.
constantly.
I thought the needle was the end of it, so I misspoke.
yeah, there's a lot of stuff that happens after that.
We got to appoint Janine the disclaimer lady.
Oh, is she the
She
person in
does
charge?
have a good disclaimer voice.
Yeah, disclaimer. She
Did
says
y'all
a
see
lot.
what JFK posted earlier today where he went on like a talk show to talk about Higgins calling in?
Yeah, he was on Jim in 94.5.
Is that like y'all's local station?
Yeah, that's like the rap station since I
Yeah.
was little.
Well, him and James were there, but James didn't get to speak very much.
Yeah, that sounds about right. That's how it
So
goes.
what happened?
Well, it was like the people at the radio station had not heard about Higgins calling into the show literally back in like December. So all of a sudden people were sending them clips of it. So they brought James and JFK on to discuss how that all went down. So
Good stuff.
Yeah, and unfortunately, Hen's song that she made for me has copyright stuff in it,
Oh.
so we won't be playing that for a while.
what do you mean it has? I don't get it.
It's got
cartoons and stuff.
cartoon
Yeah.
stuff.
Yeah.
Oh,
There's copyright's
this
not
could
just
have
for
all
sound.
been Hens'
There's-
fault.
No, It's like a small copyright thing.
It's a
Or it's like
copyright
a picture.
strike, not a copyright
Not a channel
claim,
strike.
not a strike. Yeah.
Gotcha.
Yeah. Yeah, but that I probably had 80 of them for playing that song.
We might lose Little Miss if you take the song away.
Well, it's gone, so.
Danny's so happy.
No, I would definitely set it as the outro if it didn't have anything.
He's like, oh no, the song's gone.
And I think she made the
Oh.
song. I think it's the video, not the song.
Yeah, because it's
Yeah, I
from
know, but
cartoon.
you're just like, oh well, I guess it's gone.
Yeah, but without the
Oh,
song,
boo.
without the video.
Oh well.
Danny could not stand all the attention from that song.
The pressure started getting to him. You guys don't understand. Danny DMs me at like 3 a.m. from night terrors about the song, like clockwork every night.
Yeah, that makes sense.
He
Yeah.
wakes
Yeah,
up in a cold sweat.
Can you at least send it to Little Miss where she can watch it at her leisure? I mean,
We did that.
okay. I don't know that she
We did
knows
that
that
a while
because she
ago.
like still comes on here to listen to it. So I didn't know if she had access to it
No.
herself or not.
We thought that would be the solution when it first started.
It makes
and it
sense.
didn't work.
It didn't work. Maybe
That
she
was the
needs more
first thing
explanation
that we
from
did.
She wanted to
Danny.
be able to chat about it while it was
Like,
on.
listen to this 2 times in a row, and if that doesn't cure you.
I
don't
think
know
she
what to
just
tell
likes the camaraderie of everyone in the chat. She thinks we're all dancing with her.
Yeah,
I mean,
I
like
am.
it because of where it came from and when it came.
Danny's like, we're not dancing with you, we're dancing at you.
Yeah. Danny just likes the morbid cheese part.
Yeah, cheese, the freaky looking cheese with eyeballs.
Yeah.
But I think maybe now Toy can put it in her stuff and see if she can fix it.
Yeah.
Oh
'Cause
yeah.
I think Hen wrote the song on the AI stuff.
Yeah,
maybe.
it's an AI song.
So you can do that.
No, we'll just
So she-
remaster it.
Or she could just play the music with the avatars that she made for all of us.
Yeah, but I like the
But
cheese.
you want your
I don't
cheese.
think
Okay,
the cheese
we'll
was
put your
part of
cheese
any
in when the cheese
copyrighted
comes
cartoon.
up.
Yeah,
don't
like
think-
you can just chop out those parts and put something else in there.
Yeah, I don't think the cheese was part of any major cartoon.
No.
Not with that look on his face, his cheesy
No.
face.
I mean, come
Like,
on. Most childhood cartoons are very terrifying if you break them down as an adult.
that cheese was looking at the rat the same way those pumpkins used to look at Dean.
Like I have an orifice for you, or what?
Oh, like please don't go to bed, Mom.
That pumpkin wakes up 3 o'clock every night like clockwork in night terrors. Messages Danny like, please help me.
Like, don't throw the seeds away, Mom. I'm gonna plant them.
I got plans for those seeds, Mom. I got plans.
That pumpkin's been in the sun all day, baby.
That pumpkin's been seeded.
It's been looking at you all day.
Bean seed is all in that pumpkin.
Yeah, I saw how you were looking at me at lunch.
So great. Oh man.
It brings a whole nother perspective to the whole American Pie scene. You got Dean with his pumpkin.
Yeah. Pumpkins. He's a player.
plural pumpkins.
I got a pumpkin patch, bro.
Sister wives.
It's not a healthy
The
hobby.
pumpkins. It's the
You
sister
dress
pump.
them up and name them, and yeah.
Big ones, small ones, square
Yeah,
ones.
that's kind of
Oval
BTK
one.
right there. That's a little too far.
Got like a scarecrow, but it's a
I knew when Mary B started talking that we went too far, and it was.
It's gonna go to the next level. I'm
I
sorry.
had
I'm
to
trying.
shut that off because there's no telling what she was fixing to say. No telling. We've already.
Wait, am I muted? Oh no, I'm not muted.
No, not yet.
I'm trying.
Prince Lover
Okay.
saying she's got to go, and she's wishing Happy Father's Day to the dads in here. So yes,
Oh,
Happy
thank
Father's
you.
Day to all the dads.
Thank you, Prince Lover. Happy Father's Day too.
I don't think there are any dads in here but me. Connor.
Well, I didn't know about
Connor-
Connor and Clark. Like, I mean,
Well,
there
I
are
don't
other
know about
males in
Connor.
here, but I don't know.
Well, just because you're a male doesn't mean that
That's
you
why I
didn't
said
pull
I
all the
didn't
way out.
know. I knew there were other males, and I don't know about their lineages. So I'm just saying.
A lot of males don't know their own lineage.
We'll take it. There's a possibility.
Maybe.
Happy day to the guys who didn't pull out.
Yeah.
Okay, see, Clark is in agreement. He's like, we don't know either, Connor.
Yeah, Connor may have kids. I don't know.
Dean's got a little pumpkin patch running around somewhere, but
Yeah, I got
we
little
don't-
pumpkin babies.
Dean's kids are down at the produce stand. They look
You
just like
never,
him.
you never know where these streams are gonna go. Like you could never foresee this stuff happening.
No, no.
Why would you? Why
I
would you
wouldn't.
even be trying to
None of this
predict?
stuff would ever cross anyone's mind. Normal
I was
people.
thinking about that earlier, just our voice chats and some of the where we've ended up there in recent days. It's like, wow, never
Yeah,
would have seen
Connor's
that coming.
Connor's as elusive with his fatherhood as Clark is with his location inside of America. I'm from America.
Did he say America or USA? Because there's different. That's different.
Oh, if he says USA, he's Chinese. There's no doubt.
Or US. Because America is a lot of countries.
I don't know. Connor's like boots on
What?
ground.
Mary B, what are you talking about? The United States of America?
Yeah. Clerk
Like,
says that he's in US
he's,
or
oh,
America.
yeah, that's what he said. I'm in a different state, but it's not Massachusetts.
Oh, okay.
America.
America.
Yeah, but that could mean anything. That could be like a different state of mind.
Yeah.
Yeah. Could be a different state of
A
consciousness.
different state of undress.
I thought Clark
Yeah.
disclosed where he was from, and he disclosed he was a male that night.
Connor was only wearing socks earlier, so I don't know. I don't
Oh,
think he could
wow.
undress
I
anymore.
missed that part.
Yeah, he said he was naked.
Nice.
Dean's talking like he's been in Texas forever now. That
He
boy
is.
naked.
He's got that southern twang
Happy
going.
slick.
I
That
was
boy
kind
is
of
butt
impressed with
naked in
Mary
there in
B's
his room.
America earlier.
Butt naked.
I hope not. He's got 3 screens going. Butt naked. Never mind. I'll get Mary B talking then.
Yeah, seriously. I can't stay away from the bad stuff.
I was actually impressed with your America earlier. You sounded pretty southern yourself there, Mary B.
I did? Oh,
All right.
God.
You did.
You guys are rubbing off on me.
Yeah, you sounded like a big
Okay.
MAGA supporter ready to make a commercial.
God, no.
Y'all are rubbing off on me. Mary B 2025.
I know. As soon as I said it. Ugh.
Nobody's gonna take my pumpkin's place.
Dean, is Cherry still in a bind over there in Ireland?
I mean, she has power.
Oh. So she's just ignoring us.
Dude, she was just in your chat like 2 days ago.
She might be
I
sleeping.
don't remember.
Dude, you made her a mod. What are you talking about?
I was talking about now.
Now? No, she's busy working.
Are you having problems with your memory?
No, I'm talking about now. He's talking about two days ago in the stream life, like I stream. That's like a month.
That's recent though for her in
That's what
Ireland.
made
Like,
last week so hard, difficult.
No, she's working.
But this week, yeah, this whole week sucked.
You suck.
Plus, it got hot outside in Mississippi. It's hot now. You can die
I
here.
know every one of my windows in my house is fogged up right now because it's so humid outside after all this rain and storm.
A lot of times, people don't know that their AC vents are pointing at the window, and that creates condensation, and it'll ruin the wood in your window. All you got to do is turn the vent around.
Let me go check that when I get off the stream. I had one of my units stop working this week and had to have someone come out, and it was the transformer inside of the unit. I didn't even know there were transformers in the unit, but That was $400 for just the part, which was wonderful. But you have to have it. So
I like the dad tips from Rat Daddy.
Sweet Woman says freezing in Massachusetts.
Yeah, it's well for June it is.
What's the temperature where you are?
I think it's like somewhere in the 50s right
Oh
now.
my God, that would be great.
I know we'd be out in shorts and t-shirts
That would be
working.
freaking great.
Like I'm just checking the forecast to see when there's a little bit of overcast so I can plan when to mow and stuff. Like it's that bad.
But a
It's
lot of people don't know
54.
that their AC vents, and a lot of times are pointed at the glass in their windows, especially the bigger houses, and it'll cause condensation from like 68 down
Yeah,
when
then
it's
that
hot
just drips
outside.
down onto your window sills, the wood around them.
Now, if you've got a nice, super nice windows that are double pane, high, low E, you don't have to worry about that. But if you've got less than that, it'll cause condensation, and that'll drip down on the wood, which will go through the
Yeah,
cracks in the paint seals, and it'll start
mine are definitely
rotting the
fogged,
wood.
so I'm gonna go check that.
Yeah. If your windows fog up real bad, then it's not really fog, it's just condensation.
Yeah, this is the first time this year they've done it though, but
So if it's
I
on the
will check that.
outside, which it probably is on the outside, it's
I'm
going
gonna walk up to it right now and let you know, professional, so you can advise me.
to drip down onto the drip ledge and the edge of the glass, and it's always going to win because the sun's
Okay,
going to come up
mine's on
tomorrow.
the outside because I'm wiping it off right now. So
Hmm.
can it still get? I mean, I've got screens on and then brick out here, so
No, it's just probably because the airflow is blowing right on that piece of glass.
yeah.
Yeah, it's 83 degrees here in Texas.
Yeah, it's probably hot tonight.
No, it's gonna be a low of 74.
That ain't bad.
That's because you got probably storms moving in.
No, tomorrow is a sunny day, then Monday sunny day. Tuesday is a windy day.
A rainy day, huh?
A windy day.
A Red Lobster on Tuesday.
Wednesday is sunny. Thursday is partially cloudy. Friday sunny. Saturday partially cloudy. Sunday sunny. Monday sunny. A lot of
JD is
no
talking
storm.
about 84 in New England. That surprised me so much when Bev was like, "It's going to be too hot to have court Friday." I'm like, "What?" Or Thursday. I'm like, "What does that even mean there?" But they were saying it was in like the 80s and 90s, and now it's
Yeah, it
back
gets
to
up
the
there.
50s.
Yep,
Wow.
that's how it goes.
Yeah, we're just sitting here doing absolutely nothing.
Talking about the weather. Sounds like
And
a
there's
good day.
nothing wrong with that.
Yeah,
Hanging
why's
out.
everything got to be something with
Just sitting
you?
around talking
Right.
about the weather
He's
on
always so worried
YouTube.
about his content. Like, what?
Just live on YouTube talking about the weather.
At least we moved away from pumpkin seeding, like, you know.
Yeah, we got more appropriate.
Yeah, we're up to 37 subscribers. The count started over.
And most of them were in the chat tonight, right? Like you had probably one of the highest percentile of any creator ever.
Yeah, we had about 24 out of 36.
See,
Oh,
everybody else has like hundreds of thousands of subscribers with 1,000 likes. We're doing good.
Well, I've been seeing new creators since I did this, and there's this one chick. She had 55,000 subscribers. She had 26 people in the chat. And I was like, oh my god,
yeah, that's
I would
sad.
be sick.
That sounds like bullshit.
I was gonna say it sounds like a Kate Peter channel. Like,
Yeah.
that she forgot to activate her bots.
And it's been 4 or 5 of those, and like some of them will have 60,000 subs. I'll have 120 people in the chat. And I'm like, oh my god, I'd be sick in my stomach. Like, what's wrong? But they probably get a lot of views. They may have a big rewatch crew or something. I don't know.
No, it means a dead channel or bot subs.
What is bot sub? Where it goes out and gets you some subs.
When you buy subscribers.
That's what Turtle Boy said KP was doing even with her blogs that she was writing for him. Like they were all from Indonesia and stuff. And that's how he
Yeah.
figured out like she was getting more money for her channel than what she deserved because she was paying for bot subs.
I don't want to have to do that.
You
It's
should.
not that important.
Well, no.
It also it'll stop your channel from being able to get monetized.
And how would Toy know anything personally about those to make them a chat rat?
Who?
Any of the bot subs. Like, she'd have
Like
to
a
get
bunch
very
of
creative with her chat rats for all those names.
Yeah, they'd have to
bunch
be
of
like she'd
robot
have to
rats.
make like 1,000 robot rats,
like an army of robot rats.
Terminator
Yeah.
rats.
One in a field of goats.
Connor, I don't think she used her EVT. I think she was using her advertisement money because that she got more money for those blogs based off of how many people were subscribed to her blog, and that's when Turtle Boy kind of caught on to her. But she does the same thing with her YouTube panels and all of the AKR people, same way. Plevin, the Boundless Millennium, like all those people that she's in with, it's basically the same scenario.
Yeah. I'm trying to make sure there isn't anything interesting I wanted to watch that was short that happened all week. That I know it was a few things, but I have forgotten them.
Well, let's watch them.
Yeah, but I don't know what they are.
We got to get to 420.
The police
No, let's go ride
officer that
Turtle.
spoke on TikTok, I started following him after he came out talking about the investigation. Did y'all see that one?
No, not yet.
No.
Yeah, let me see if I can find it real quick because I don't subscribe to a lot of people on TikTok.
Dean, can you adjust that time length on the subscriber chat?
What?
The
like make it so it's longer?
no.
Make it
20
so
minutes.
it's shorter?
What's up, Cherry?
Hey, Cherry.
Yo.
We're going to ride turtles, but we got sidetracked.
Can I change? To be honest, I've never like I know I've been doing YouTube for a while. I've never changed it to subscriber mode. But Cherry clearly knows how.
Yeah.
If so, you wanted the thing like the time change to shorter? Is that what you were asking?
Maybe 5 minutes. I don't really care. Toy said 20 minutes is fine. Seems like a long time for me.
Hey, Cherry, Danny, I sent you the link of that police officer. It's in TikTok because I don't know if you can show it or not.
We'll look at it and see.
There's no music. He's just sitting in his cop car talking about the case.
Oh, he's talking about Karen Reed?
Yeah.
Let's see what happened.
Tell just by looking at this jury there.
That's not it. It swapped over. Hold on. I don't know why I did that.
Let me go back and get the name for you. You can probably just pull his channel up. It's called Bake, Bake, and Lay, LA. Bring it up, and it's his last video.
I think it's just me. That's what I think.
What's just you?
That I clicked the wrong button. The wrong button.
No, I don't see it there.
No.
Hang on. It's showing up to me.
Oh, well. We'll figure it out next time. Bye, Cherry. Don't work too hard.
I had just.
You need to get those some moisturizer for those goat nipples. Them things may be raw. A lot of milk. Do you know what the price of that is, especially from a male goat? An ounce of that stuff, baby, you got 10, 12 ounces of gold.
That's funny.
It's the truth. Sometimes the truth is funny. There's nothing you can do about it. But we have to pool our money together to get Cherry an order of chicken fries.
They're so gross.
Oh, hush it, Mary B. You haven't had good chicken fries up there in New England.
Yeah, they're probably just really bad here, honestly.
And it really is hit or miss here as well. It depends on the Burger King. Like
Yeah, it's like sometimes, because I've had them a couple times, sometimes they're just so dry.
dry and chewy and been sitting around. But if you ever go, like that was the whole plan when Cherry was coming like here for her trip. I was going to be like, all right, you have to make fresh ones. She's traveled from Ireland for these. So please make her fresh ones so she can have a true, experience with good chicken.
We'll wait an extra 20 minutes. So it's in total, we'll wait an hour for these chicken fries.
Right.
And they're completely different from like the grocery store frozen chicken fry section,
Yep,
Yeah,
I've
these
never
are
had those.
Made fresh on site chicken fries.
Oh, guess what I had today, Laleen?
What's that?
Chicken
A
fries.
Totino's pizza.
I have some in my freezer. Those might be on the menu for later tonight, but I also have some gumbo in the refrigerator that I thawed out and might go
I
that
love
route
gumbo.
too.
Yeah, gumbo's really good.
Yeah.
Did you make it?
Yeah, I made it. And I just had a bunch that I put up in the freezer. Like anytime I make chili or gumbo or even roast, like I'll have like a lot left over, so I'll freeze it and thaw it out.
Yeah, my
And make fresh
parents
rice.
do that.
Yeah. But yes, I've never made Tostinos in the microwave though, and roll it up like what you were talking about last night. That was new to me.
Yeah, no, I just roll it up into like a giant cylinder and then I eat it that way. It tastes better. It tastes better.
I like the softer crust. Like, you can put it in for longer and it'll be softer crust versus shorter and kind of crunchier. I
Mhm.
like it when it's softer. So, how long do you cook it in a microwave? I've never tried this.
3 minutes.
I like
A
it when
full
it's softer.
Tostino's pizza?
Laleen
Yeah,
2020.
Shut
3
up,
minutes.
Danny. A full Tostino's pizza in a microwave only 3 minutes?
Yeah, I'm talking
Wow.
about like those rectangular ones. Like,
Well, they're squares, yeah.
yeah, 3 minutes.
Holy cow. I mean, that's a good 16 minutes on 450 in the oven.
Yeah,
I'm gonna
3
have to try
minutes.
this.
You can do like 3 minutes 30 seconds if you want, but I do 3 minutes. It makes it so it's like it's warm, but it's not like burn your like mouth hot.
Yeah. See, Toy Dean went and had a hot pocket last night after we were talking about Tostinos, so he's good with it all.
I did have a hot pocket. I think I'm out.
Y'all been watching this Karen Reed trial.
That's it right there, Danny.
Okay, let's see if it'll stay on it this time. Nope. Mother.
And just pull it up yourself in your own TikTok, because sometimes when you're using people's links, it'll go to the next video. I put his information in that post. It's like BAKE and Livey Bilbrey is his name, and it's his last video.
So what are we doing?
Just shut up, Dean.
Whoa!
He's having technical difficulties. He's getting a little testy, Dean.
Yeah, he's got little testes.
It's not gonna let me. Just not gonna let me.
Yeah, visit the site, motherfucker.
I'm visiting site.
All rise, motherfucker.
That's it right there. The one that's on your screen, if you can play that one.
Unmute it, motherfucker.
We find a dead guy in your front yard.
Dean.
Crime scene tape. We knocking on your front door, and I don't give a damn if it is a house full of cops. We're gonna have questions, and one of the main questions we're gonna have is, can we have consent to search the interior side of this house? And if you deny that, I don't care. We got to call the man upstairs down here to get it. We get a search warrant on that house. That being said, always back to Brothers in Blue. Told the truth. You was within Florida state statute. You was within policy. And you felt like you was right doing what you did. Back you all the way to the end. 100%. You did some dumb shit. You got caught. You lied about it. Deuces. That's on you, man. You messed up. Have a nice life. I'm a pretty good read of body language. And I ain't saying them cops are lying when they're sitting up there, but they dang sure ain't being forthcoming with the information that they know. And by a long shot, I ended up finding myself in that situation. I can tell you one thing. They asked me for my phone. I hand it to them. Because I got 12,000 pictures of my friends and family and outings and my baby girl on this thing. And I ain't destroying it for nothing. I ain't pulling out SIM cards and putting it in 2 different locations, one on an Army base and all that BS. I hand it to them. Now, I may have some marketplace purchases that were a little bit questionable. Some of my Snapchats may be a little bit personal. But at the end of the day, there ain't nothing on my phone that I'm scared of anybody seeing. And I'll tell you what, when she's acquitted at the end of this thing, there's a prosecutor somewhere needs to be handing out some perjury charges, like popsicles on a hot summer day. That stuff corrupt all the way to the top, in my humble opinion.
In my humble opinion.
Yeah.
Yeah, so it's a good time to be done.
But we're not at 420 yet.
No, we're not.
Hey, Danny, what time is it?
I wasn't ready.
Damn it.
Too soon. Too
Oh.
soon. Not a lot too soon. Just I wasn't ready.
All right. Now you're ready? Yes?
Yeah,
How much
we're
time
ready.
do we have?
Puff, puff, pass. True crime chat rats. Let's go. Puff, puff, pass. True crime chat rats. All across the world, we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rat pack. With my rats chatting about the crimes, the players, and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats. True crime social, where we be every night, doing everything we do for the truth. With my rats chatting about the crimes, the players, and the evidence. Like it all went bad. Taking all the facts, and we bring them to the chat rats. All my people on the internet, all my people from around the world, gonna take you to the place we know best. Cause we're coming through like that. Puff, puff, pass, true crime chat rats. All across the world, we coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat. I be rolling with my rap pack. With my raps chatting about the crimes, the players, and the evidence. Where it all went bad. Taking all the facts, and we bring them to the chat rats.